Bonjour. This video is the second of a series of two discussing the impact of legal education on the development of legal systems. This time I will address legal education in the common law world. If we look at university education, England adopted the Bologna model, just like other countries on the European continents. Did you know that until the 18th century, the only law you could study at Oxford and Cambridge universities was Roman and canon law? Sir William Blackstone, who published well-known commentaries on the laws of England, was the first professor to teach the common law at Oxford University when he was made Vinerian professor in 1759. Until the late 19th century, few English lawyers had received legal education at the university. Nowadays, most of them do, though it remains possible to practice without a law degree. How then did English lawyers receive legal education? The short answer is that they were trained as apprentices rather than school educated. By the time the University of Bologna was setting up its very influential curriculum, the newly introduced Norman dynasty created a set of highly centralized royal courts that developed over time a common law on a case-by-case basis. The administration of the kingdom was centralized, and by the 15th century, local laws and customs had lost significance to be replaced by the emerging common law. This caused more and more cases to be pleaded in London and fewer elsewhere in the country. Inns of court were created in 1340 to host lawyers coming to London to argue cases, hence their name. These 4 Inns of Court still exist today: Inner Temple, Middle Temple, Gray's Inn, Lincoln's Inn. Inns of Court later became permanent place of residence for lawyers and centers for the legal education of students and practitioners. Dolores Freda, professor at the University of Naples, has studied and compared legal education in England and continental Europe between the Middle Ages and the early modern period. You can read her contribution in Comparative Legal History, a book that I recently edited. That's chapter 9. Here are her findings. Exercises at the Inns of Court consisted in readings, which were detailed lectures on a statute, followed with debates between the reader, the barristers, and the students. The other learning exercises were the moots, also called cases, which were types of simulated trials. Overall, the approach was very practice-oriented. Students also followed barristers in the courtroom to hear their arguments, the judgment, and the reasons assigned by the judge. The early law reports, called yearbooks, were based on notes taken by the students. Back then, they didn't do law review, but they did some form of law reporting. Barristers, judges, and students also gathered around formal and informal dinners in the hall of the inns. And this resembled college life, such as in Cambridge or Oxford. The architecture of the building is actually quite similar, as you can see if you visit Oxford and Cambridge and the Inns of Court in London. Splendid buildings. Professor Freda describes the exercises at Continental University and finds striking similarities. They had the lecture or lectura given by a doctor and based on the Corpus Juris Civilis, followed with questions and debates, questiones disputate, meaning problems discussed. These were doctrinal questions on the law and practical questions based on facts. Doctrinal discussions came with arguments in favor of a solution, argumentum pro, or against it, argumentum contra. The disputed questions brought a practical element in the curriculum when they were argued on the facts of a hypothetical or real case. Another scholar, Professor Fernando Toller of Austral University in Buenos Aires, he once taught at LSU Law, discusses the use of the case method in medieval universities in Europe, in continental Europe, and he recommends its revival. Read his Foundations for a Revival of the Case Method in Civil Law Education in our Journal of Civil Law Studies, Volume 3, 2010. Legal education was more doctrinal on the continent, but included a solid practice component that disappeared maybe sometimes in the 18th century. So, England did not revive the Roman canon law, and this is because the system of the royal courts developing a common law was already in place when the teaching of Roman law started. This does not mean that there is no Roman or canon law influence on English law. Such influence prevails in the part of the law called equity, which was administered by the Chancellor, who tended to be a high educated clergyman. The development of the common law caused justice to be centralized in London and triggered the development of an autonomous system of legal education. Nowadays, future lawyers receive university education and then practice as solicitors, and those who specialize in higher court litigation, called barristers, receive additional training at the Inns of Courts and have their chambers there, a few steps away from the central courts, which is very convenient. Judges are appointed among barristers, and they keep belonging to their inn once a judge. So the Inns of Courts function like a professional club. What happened then in the United States? During the colonial period, some lawyers came from England where they had been trained at the Inns of Courts. It took a long while for legal education to develop on our side of the Atlantic. Most attorneys were self-educated by the reading of Blackstone's commentaries of the laws of England. William and Mary Law School opened in 1779. The Harvard Law School was founded in 1817. The University of Maryland School of Law was chartered in 1816, but did not begin classes until 1824. The teaching method was based on lectures, just like on the continent at the time. Now, listen carefully. Because of universal reliance on the work of Blackstone, and due to lecture-based teaching, 19th century legal practice in the US was less fact-driven than it was in England. True, they used the common law form of action, common law terminology, but rather relied on principles derived from cases than on subtle fact distinctions. Courts relied on legal treatises, first Blackstone and later those written by Kent and Story. The temptation was great to adopt civil codes on the model of the French or the Louisiana Civil Code of 1825. In 1850, the state of New York adopted a civil code that had been drafted by David Dudley Field, but it was vetoed by the governor. California followed suit, adopting a civil code in 1872, as did also the Dakotas and Montana. Though based on common law doctrines, the layout and style resemble the French and Louisiana civil codes. The US were wavering between common law style and civil law style of lawyering. The system was formalistic. The most relied on publications were not the law reports, but treatises like those written by Kent and Story. The question comes, what did cause the change and the move to a more common law style in the US? The answer is legal education. Once again, I will refer to an LSU-based publication, see Jacques van der Linden, is the pre-20th century American legal system a common law system, in the Journal of Civil Law Studies, volume 4 for 2011. The culprit, Christopher Columbus Langdell, Dean of the Harvard Law School, who launched a revolution in the late 19th century when deciding that out of scientific reasons, the study of the law should stem from cases. As van der Linden has it, I quote, "Intellectually, the rediscovery of the principle by the student through the study of the judge's reasoning was educationally more fruitful than the reading and memorization of what the treatise said." Unquote. The Socratic method was born as the principal tool of legal education. The focus was to be on cases, hence the name case method. Whether the Langdellian method privileges the discovery of principles or is pure inductive analysis remains a matter of dispute. It remains true to this date that the English approach to precedent is more fact-based and the American approach more principle-based. But it is also true that in either place, court decisions occupy the central place, and the Langdellian shift in legal education has, at the very least, strengthened this pattern. Now, what next? For history is always on the move. What are the most recent shifts in legal education? It becomes more and more practical with the development of law clinics and experiential learning. I will, however, point to another direction. A few law schools, not many, adopt a pluralistic mode of legal education. In the past, the Bologna model was a combination of Roman law and canon law. The emerging paradigm nowadays is a combination of civil law and common law. In the US, you call it the LSU model. In Canada, you call it the McGill model. It can be by jural education, like at LSU, where the two systems are taught in separate classes, or it can also be transsystemic, like at McGill, and see on this the article by Rosalie Juquier in the Journal of Civil Law Studies, volume 12, 2019, From Labos to Le Bayou, a transsystemic voyage. What do we mean by transsystemic legal education? Well, you study contract or property based on the combined approach of civil law and common law rules, plus other rules like autochthone laws. A few law schools in Europe adopt one model or the other. I will cite the University of Maastricht in the Netherlands, University of Luxembourg, Trento in Italy, Bucerius in Germany. This is a new trend, and this is why I moved from a prestigious position in Europe to LSU. Harvard also understood that some change is needed, but they move slowly. First-year student at Harvard now must take a course in international or comparative law during their spring semester. But do not worry, I won't move to Harvard until they adopt the LSU model. It is too early to speak of a systemic influence of civil law, common law teaching, but it surely makes students smarter and more intellectually agile, like people who speak multiple languages, and it prepares you to better legal practice in a global world. It also helps find the best solution when doing law reform. Legal education informs who we become and what we do, and necessarily it has some impact on legal systems. Thank you.